Judgment in the matter of UniCredit Bank against RusChemAlliance.
Lord Legate will explain this judgment.
The question raised on this appeal was whether the English courts have jurisdiction to order a Russian company not to pursue court proceedings in Russia against a German bank when the parties had agreed to settle any dispute between them by arbitration in Paris and had chosen English law to govern their contracts. A Russian company called RusChemAlliance LLC, which I will call RusChem for short, engaged German contractors to build gas processing plants in Russia. UniCredit Bank, a German bank, issued bonds to guarantee the contractors' performance of their obligations. The bonds were governed by English law and stated that any dispute arising in connection with them was to be settled by arbitration in Paris. Following the Russian invasion of Ukraine in February 2022, the European Union imposed sanctions on Russia. The German contractors announced that because of these sanctions, they were not able to perform the construction contracts or to return advance payments made to them by RusChem under the contracts, which amounted to around €2 billion. RusChem then demanded payment from UniCredit Bank under the bonds which guaranteed the contractors' performance of their obligations. But the bank also refused to pay, again citing the EU sanctions. RusChem brought legal proceedings in Russia against the bank, claiming the amounts which it alleged were payable under the bonds. The bank objected that RusChem had agreed to settle any dispute in connection with the bonds by arbitration in Paris. However, the Russian court declined to dismiss RusChem's claim. To try to stop RusChem from pursuing the Russian proceedings, the bank applied to the English court, claiming what is known as an anti-suit injunction. RusChem disputed the jurisdiction of the English court to hear this claim. In the High Court, the judge held that the English court did not have jurisdiction to hear the bank's claim for an anti-suit injunction. The bank appealed to the Court of Appeal, which allowed the appeal and granted an injunction ordering RusChem not to continue the Russian proceedings. From that decision, RusChem appealed to the Supreme Court. The Supreme Court heard argument in April, and because of the urgency of the matter, announced its decision shortly after the hearing on 23rd April, with the reasons to follow later. The court dismissed the appeal and upheld the injunction. The reasons for this decision were given in a judgment by myself, Lord Legate, with which the other justices agreed, that was published on 18 September. This is a short and necessarily simplified summary of those reasons. To establish that the English court had jurisdiction to hear the claim, the bank had to show, first, that one of the grounds, commonly known as gateways, on which a claim may be brought in England against a foreign defendant, applied, and second, that England and Wales was, quote, the proper place in which to bring the claim. The gateway on which the bank relied is available where a claim is made in respect of a contract which is governed by English law. The bonds all stated that they were governed by English law. But RusChem relied on a principle that an agreement to arbitrate disputes is treated for some purposes as separate from the contract in which it is contained. The bonds all contained clauses stating that disputes were to be settled under the rules of arbitration of the International Chamber of Commerce, and that the place of arbitration shall be Paris. RusChem argued that the contracts in respect of which the bank's claim was made were these arbitration agreements, and that the choice of Paris as the place of arbitration signified that the arbitration agreements were intended to be governed by French law. The applicable legal principles were discussed by the Supreme Court in 2020 in a case involving a company called Enka. In the Enka case, the Supreme Court made it clear that a choice of law to govern a contract will generally be construed as applying to an arbitration agreement which is incorporated in the contract, and that the choice of a different country as the place of arbitration is not, by itself, enough to displace this conclusion. RusChem relied, however, on some remarks made in the judgment in the Enker case, suggesting that the position might be different if the courts of the country chosen as the place of arbitration would regard the arbitration agreement as governed by their own law. There was evidence that a French court would regard agreements to arbitrate disputes in France as governed by the French law applicable to international arbitration agreements. RusChem argued that the potential exception to the general rule contemplated in the Enker case applied, and that as French law would be regarded as the law governing the arbitration agreements when the matter is looked at in France, it should be regarded as the law governing the arbitration agreements wherever the matter is looked at, including, therefore, when it is looked at in England. The Supreme Court rejected that argument. The argument made in this case was not made in the Enker case, and the remarks made in the Enker case on which RusChem relied are not conclusive. Having heard argument on the point, the Supreme Court considers that the approach contended for by RusChem is over-elaborate and attributes to contracting parties a process of reasoning which is unrealistic. When commercial parties agree on a place of arbitration, it is unrealistic to treat this as an agreement that the arbitration agreement should be governed by whatever law the courts of that place would regard as governing the arbitration agreement. No such complex intention can sensibly be imputed to the parties. Instead, the correct interpretation of the terms of the bonds is the straightforward interpretation that in accordance with the general rule, the parties' choice of English law to govern the bonds includes the arbitration agreements which are incorporated in and form part of the bonds. The Court of Appeal was therefore right to hold, as it did, that the arbitration agreements in the bonds are governed by English law. The bank's claim therefore fell within the gateway that allows a foreign defendant to be sued in England where the claim is made in respect of a contract which is governed by English law. The second question was whether England was the proper place in which to bring the claim. RusChem argued that the proper place in which to bring the claim for an anti-suit injunction was either the French courts, because they are the courts with responsibility for supervising any arbitration of a dispute in connection with the bonds, or before an arbitral tribunal in such arbitration proceedings brought pursuant to the arbitration proceedings in the bonds. The argument assumed that to establish that England was the proper place in which to bring the claim, it had to be shown that the English court was a more appropriate tribunal than any other tribunal to grant an anti-suit injunction. That would be the relevant test in a case where there was no contract stipulating where claims must be brought. But when the parties have contractually agreed that any claim must be brought in a particular place, as they have in this case by agreeing that any dispute must be settled by arbitration in Paris, in the Supreme Court's view, that bargain should in principle be enforced by any court which has jurisdiction over the defendant. Thus, the fact that RusChem can be sued in England because the claim for an injunction falls within the relevant gateway is enough to make England the proper place in which to bring this claim. The courts of the place of arbitration have a special responsibility for supervising the arbitration, but they're not the only courts which can prevent a party from breaking its contract to arbitrate. In any case, on uncontradicted evidence, the French courts would not have jurisdiction over RusChem, and even if they did, have no power to grant anti-suit injunctions. Such injunctions are not part of French legal procedure. The French courts are therefore not even an available place, let alone the only proper place, in which to bring the claim. As for the suggestion that the claim for an injunction ought to have been made in arbitration proceedings, it was accepted that an arbitrator could, in theory, make an order directing a party not to pursue court proceedings brought in breach of the arbitration agreement. But such an order would have no coercive force, because arbitrators lack the powers available to a court to enforce its orders, which include sanctions for contempt of court. An order made by an arbitrator creates only a contractual obligation. RusChem is already under a contractual obligation not to bring proceedings against the bank in the Russian courts, which has not deterred it from doing so. it is clear that an order made by an arbitrator would be wholly ineffectual to prevent RusChem from breaking its agreement to arbitrate. In circumstances where the bank could not obtain any effective remedy in the French courts or from an arbitral tribunal, the Court of Appeal was right to conclude that England and Wales is the proper place in which to bring this claim. It is for these reasons, explained in much more detail in the published judgment, that the Supreme Court dismissed RusChem's appeal against the grant of an anti-suit injunction.
The Court is now adjourned.